You're watching the Business Channel, creating business class programs.
Patents, design, copyright, they're the lifeblood of manufacturing business. And at the heart of the sector is Marks & Clerk, an intellectual property services company. Simon Mountaineer is a partner. What is IP in a nutshell, and how does it relate to manufacturers?
Well, intellectual property, if you like, it's the output of your research and development. It's the output of your creativity. It's the assets that you can't touch. So it's the concepts and it's the ideas. It's all the stuff that really underpins the products that you're producing. You have various kinds of IP. The most famous one, I suppose, is patent protection, and that protects the functionality of what it is you're producing, the way something works, the technical advantages that it offers. But you also have trademarks, which are the brands. They're the identity, if you like, not only of the products you're producing, but also of your company. And then you have designs. You can register a design, and that relates very much to the appearance of an article.
What are the risks for manufacturers who aren't IP protected?
Well, the risks are that as soon as they go to market, as soon as they put the product, if you like, in the public domain, it's there for everyone to see, and if they like the look of the idea, they can just go along and make something very similar. How
important is IP protection to a young business starting up?
Well, it can be important in a number of ways. The important thing to remember is that with a younger company, a start-up company, they very often don't have the resources and the infrastructure and, if you like, the financial power to compete with a lot of bigger, more established companies. If they don't have IP protection, they can put something out in the marketplace and the bigger players can come along and look at it and say, well, I like the idea of that. And it's very, very easy sometimes for them to get into the market and actually just sort of swamp the smaller company and really just sort of like blow them out of the water. If they have IP protection, it actually gives them something that they can fight back with because their position is protected. Another way that it can be very important is that a lot of the time with smaller companies, they are seeking investment for various stages in the development of the company. And as an investor, what you're doing is you're looking obviously for as much security as you can hope for in your investment. And if you know that the IP is protected, you know that if you put your money in, there's a much lower chance that someone else is going to come along really and sort of encroach on the territory. And also with suppliers, distributors, retailers, sometimes, not always, they want exclusivity. It can give them a much stronger position in the marketplace. And they can only really expect to get that if the product is protected, because a competing product could come along and could be sold more cheaply, and that could actually undermine their position as well.
What sort of costs are involved, and is it a worthwhile investment?
Well, typically to get a patent for an invention in a single country would generally cost an average of about £5,000, maybe a little bit more, occasionally a little bit less. It depends very much upon the nature of the invention. Very sophisticated, technologically complicated inventions can actually cost quite a lot more, but I would say, you know, £5,000 to £6,000 is an average. Might sound like a fair amount of money, but that's spread over a period of 2, 3 or 4 years. And if you compare it with other things that you might be spending your money on, I suppose it compares very much with a sort of half-page advert in a trade magazine or something like that.
Somebody running a business may worry that they're coming to you as a patent attorney, but what do you know of their business, of their invention?
Well, patent attorneys all have a science or engineering degree, at least, and very often they have a PhD as well. So they all have a technical background which will enable them to understand inventions within certainly a decent range of technologies. And it's very important not only to be able to analyse the technology, but also understand the commercial priorities for that technology and where the business wants to take the technology and what the purpose of the invention actually is. So a patent attorney would typically be very comfortable doing that. It's a core part of the job. And then once that's understood, it's a case of really identifying what the concepts are, and then really looking at the legal aspects of it and framing it in such a way so that the maximum possible protection can be achieved.
Simon Mountaineer of Marks & Clerk, thank you very much indeed.